Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
Today, we got John Romano. We got an early start, of course, because John works 7:24, so we're getting a 6 a.m. start here on the West Coast, so we can get a little time with John before he starts his heavy schedule today. So, good morning, John Romano.
Well, good morning, Dan Ambrose. I'm glad to be here. I'm looking forward to this. It should be a lot of fun.
Yeah, we've only known each other for about 10 years, and this is my probably like 70th podcast. We finally got John Romano to find some time to join us on our podcast.
Big day for me. I'm glad to be here. As you know, I've been following you since day one and all of the things you've been doing in CLE throughout America. So I'm looking forward to this. It'll be fun.
Where did we first meet? I know it's been at least 10 years. It's been a while.
It was in an event out in California where we met just briefly, but then we met when you were in West Palm Beach and you were here teaching and instructing on a program, and we had time to sit down and talk. And then later that night, we went to dinner with a group, and that's when we got to really know each other.
All right. But it seems like forever because I have no memory of my life before John Romano was in it. So that's just how far back it goes.
That's good. That's good.
So, but John, when did you've been a lawyer now for how many years? More than 50, right?
51 as of May 10th in just a few days.
All right. So we're still in the 50s. That's almost as long as I've been alive. That's amazing. You became a lawyer when I was just 7 years old. So when did you first get the inclination that you wanted to be a lawyer, though? And where did it rise from?
Dan, I was about 10 or 11 years old, and it was around the time that I started really paying attention to the news and to politics. And my dad had a good friend who was a trial lawyer here in South Florida. And I just thought he was the sharpest, coolest, smartest guy I'd ever seen. And I thought that is something I would love to do. It was a part of, I had always thought about what do I want to do? What do I want to be? One was because of the influence of Marines in my family, an older brother and several uncles. I always knew I wanted to go into the Marine Corps. And then because of the influence of seeing this lawyer, I thought that is something I'd like to do.
So you get the inclination. And so how does that inclination come to life?
Oh, goodness. I would say right around that time, anytime I could get up in front of people doing anything, I started doing it. Throughout high school, I was involved in politics and student government. Actually, in 6th, 7th, and 8th grade, Dan, this is a bit of trivia you probably don't know about, but I was a soloist on a local South Florida amateur show as a singer. And I would sing every Sunday for a 2.5 year period. And it was great because you're getting up in front of an audience, and every week it was a different theme. It was Western week, and I dressed up like a cowboy and sing a Western song. If it was Easter Sunday, they'd have me dressed in a suit, sing a religious song. It all depended on what it was. But those events, getting up in front of people, starting to network at a young age is what brought me to that birth of ultimately getting on to law school and becoming a lawyer.
Well, that's a very great opportunity you had as a kid to be a performer and gain your presence and your comfort in front of people and overcome whatever insecurities or fears that we all have as human beings, when we stand up in front of an audience. So that is a great start. But also you played a little bit of football. I think that, is helpful too, because in my experience, people who played, high school, especially college sports at a higher level, competitiveness tends to bleed over into law, into the courtroom. And so give us a little background on your football career.
Oh, yeah. I started playing football at a young age, organized football from 6th grade right on through high school, and then signing a football scholarship with Florida State, but going through recruiting all over the country. And it was a very exciting time. But to me, what football was all about, as I think back on it, it's not just the bonding you have with the other players. And it's not just the lessons you learn from your coaches and from your teammates. But it's that with football, you are in a perilous situation every play. It's a unique sport because of the danger. And yet you never even think about that when you're a kid. You know it's there, but you're not worried about it. You're not focused on it. And I think that is one thing that really, really helps. And I learned something. This was in my sophomore year when we were permitted to play varsity starting in 10th grade back then, not ninth grade. And in the very first game, I was a tailback, and I had a very long touchdown. And the one thing I remembered later that night when one of my brothers asked me, how did it feel to score the touchdown? And I said, Randy, this is going to sound really weird, but crossing the goal line wasn't when I really was excited. It was that split second when I broke free. And you realize nobody's going to catch me and I'm going to score. And there's something about that in life. So that when you hear people say it's about the journey, not the destination, it's true. It is the journey. And that's what is so extraordinary about football, about the Marine Corps, about marriage, about life and family. It's that journey that is so thrilling, and it keeps you just wanting more and more every day. So very, very exciting. All of that started in many ways with football.
And the Marine Corps. So you played football in high school and obviously college at FSU.
And then
And
on to
did
the
you ever,
Marine Corps.
and then onto the Marine Corps. You never thought about playing professional football in the
Well,
NFL?
I was not going to be good enough to play professional. I didn't think so. It was a matter of getting on to law school and doing the Marine Corps. I was given the opportunity to be a part of what was called the PLC, Platoon Leaders Class program, where you are permitted to go to law school while you're actually signed on as a Marine. You go to boot camp the first summer of law school, 3 months of boot camp, finish law school, take the bar exam, and then you go on active duty. And what is so unique about the Marine Corps, and this part of it is different from the other branches of the armed forces. The Marine Corps has a philosophy. Every Marine is a rifleman first. Therefore, in the Marine Corps, whether you're JAG, whether you're a pilot, whether you're artillery, supply, it doesn't matter. 3 months of boot camp, which is all infantry training. It's called OCS, Officer Candidate School, and it's boot camp with Marine Corps drill instructors. When you complete that, you then go on to 6 months of advanced infantry training. And then, now 9 months into it, you go to the Naval Justice School in Newport, Rhode Island. And it's an extraordinary experience because that first 9 months is all running and jumping and learning about leadership and military history and fighting and marching and war strategy and all kinds of remarkable things. And all of that is the precursor, then off to the JAG school. So it's very unique.
How do you think playing football and being in the Marines? Well, how long did you serve in the Marines?
3 years plus boot camp. So basically 3 years and 3 months.
And how did that service, I guess, inform or affect how how you practice law?
It's all about attitude. And not any person, but almost any man or woman who wants to can become a Marine, but it requires a very special devotion. But you don't have to be some 6'5" physical stud or some woman who can pole vault 15 feet. What you have to be able to do is carry your own weight and learn leadership the way they teach you. And then what happens is you are learning lessons about life, how to deal with other people, how to deal with failure. Marines deal with failure, not with despair, but with hope. so that if you fail at something, you go, all right, let's put together a plan so that failure never happens again. It's the same thing in law. It's the same thing that we teach our kids. So it's just one extraordinary lesson after another.
And in the Marines, did you get some trial experience in the Marines?
Well, the answer is yes. And I was very fortunate because when I made my request coming out of the officers' basic school, I had actually asked, where in the Marine Corps can you be assigned where you will have the most jury trials? And there were two places. One was Camp Lejeune, North Carolina, the highest in terms of trials, and the other was Camp Pendleton in California. So I was assigned to Camp Lejeune, immediately went into defense, and I was only in defense roughly about 7 months or so, and then I was transferred to prosecution, and they had me as a prosecutor the remainder of the time. And all of that time, it was prosecuting and defending felony cases, and it was every kind of case: rape, murder, robbery, and an assortment of military crimes.
And how many trials did you get in between the prosecution and the defense?
Approximately 125, but that included jury trials and non-jury trials. And I would say of those, it's hard to put a percentage on it, but probably 50 were jury trials and the others were non-jury.
All right. And so you go through and you get your experience in the military, and now it's time to, come back to civilian life. And so tell us about where you get started in your civilian legal career.
All I can say is the stars were aligned, because when I came
they've been aligned for you for like 75 years. All right.
I have to say that's true, because since the day I was born, the stars were aligned. I just feel like in so many ways I've been the luckiest person alive. But when I was getting ready to take the bar exam, I was clerking for a wonderful law firm in West Palm Beach, with two of the partners being former presidents of then ATLA, now AAJ, Al Cohn and Ward Wagner. And I didn't realize at the time how extraordinary that was, to be with a firm with the caliber of lawyers like that. In fact, Al Cohn was the founder of the Academy of Florida Trial Lawyers. And it became FJA, or our Florida Justice Association. So while I am on active duty, this firm had said, we want you to come back with us. And Dan, they even made up new stationery and they put my name on it while I was on active duty. And it had in parentheses, it had my name, John F. Romano, parentheses, USMC on military leave. And it was extraordinary, because while I'm on active duty, I know I'm going to be able to come back to this extraordinary law firm where all they do is try major cases. And when I finished, came off active duty in late October 1977, Nancy and I had 4 kids at the time, and I went right to work. And I remember getting back to West Palm Beach on a Thursday night. I go to the office Friday morning, and the office manager says, what are you doing here? We assumed you were going to take a couple weeks and get settled in. I go, I don't need to get settled in. I'm ready right now. And I started work that morning when I got back, and it was just extraordinary being with that law firm and all of the men and women in that law firm. It was great.
And so you get started. Do they give you a couple of cases to get you going?
Amazingly, again, when I go back and I say I've been lucky and I've been blessed and whatever terminology you can come up with, Al Cohn calls me in his office and says, Johnny, I got this case I want you to look at. We're not quite sure what to do with it. And it was a case where James Stanley, who had been the youngest master sergeant in the history of the United States Army, he and others had been given LSD without their knowledge back in the 1950s as a part of a government project regarding spies. And he says, look it over. A short while later, Ward Wagner calls me into his office and he says, John, I have a case I'd like you to do with me. but I want you to start doing the workup. And that case involved a little child, a 6-year-old child, who was attacked and was killed by a crocodile at an amusement park in South Florida. Those two cases, Dan, changed my life, changed not just my career, but I've always thought of it as what I do as a calling. And I couldn't wait to get in to those cases and get going. And the crocodile case, it ultimately resolved within a reasonably short time after that, just a few months. But the Stanley case involving LSD being given to the soldiers, it took me 22 years to bring that case home, including one trip to the Fifth Circuit after we won at the trial level, 2 trips to the 11th Circuit after we had won again, and then on to the U.S. Supreme Court, where we lost in a 5-4 decision written by Justice Scalia.
What a surprise.
I know.
Justice Scalia screwed over the little person.
Oh, and then a lawyer from the Justice Department calls me and says, well, good job. You all have worked hard on this, but, maybe I'll see you someday. I said, well, it ain't over. He said, no, it's over. I go, it's not over. And we filed a private claims bill in the House and Senate. And ultimately, it was signed into law. But Senator Strom Thurmond would only let us get the money if we had a trial. And he actually put a cap on the damages. The long and short of it is in 1997, okay? So now we're all these years later, we finally get an okay to move forward with the trial. And we had the trial. It was on court TV. We won, but it was not a jury trial. It was a very specially put together by the government arbitration panel. But we prevailed with the panel. Sergeant Stanley was able to recover money, but it was just dastardly what had been done to him.
John, you went to boot camp there before you became a Marine, but it wasn't your only time at boot camp. So you recently had a boot camp here in Las Vegas. Can you tell us a little bit about that experience?
I've already told people about this experience. It was extraordinary. It was an eye-opener for me. I did this with you and with others at Trial Lawyers University in Vegas back roughly 3 or 4 weeks ago. And the part that I was involved in, we were starting at 7:30 in the morning with breakfast at what I call the 3 condos that you have there together. I think we were pretty much in 2 of them. And then right at 8 o'clock.
We're working on the remodeling of
I got it.
We got little contractor issues, as people have. We had real contractor issues.
Well,
delays,
right at,
staff, the typical contractor.
And then at 8 o'clock sharp, everyone was in his or her seat. And I had the privilege of being able to start with somewhat of a lecture presentation on damages. And I did that for about the first hour. And then from 9 o'clock to 12:30, it was back and forth, everyone interactive with one another, asking people in the audience, tell me about your case, problems you're having in your case, issues you want to discuss. And I'd go to lawyer number 1, and I'd say, okay, here's how we can help you. Here's what you need to do. Do this, don't do that. Let's try this. Let's think about this. And then we go the next student, the next student, the next student. Before you know it, you're in there yelling at me, stop, stop, stop. It's 12:30. I mean, I couldn't believe it that we had just gone through all that time. Then at 12:30, we jump in the vehicles. We go to a great restaurant where the food is waiting for us. We all eat together for an hour. We come back, and then we start promptly at 2, and we go to 6 or 6:30, and it was more of the same. The great thing, Dan, I think I learned more than any of the attendees. I was learning from them. I was learning from their cases. Some of them were bringing up strategies and tactics and techniques that I had never heard of. And I thought, oh my God, this is incredible. And I took them back to our office and was telling our lawyers about them. And then we had a spectacular dinner with everybody that night. And then we repeated everything the next day. and did it in a unique and different way. But it's not just a boot camp, it's an intense integration of brains coming together to try to work through issues on cases to make us better lawyers so we do better jobs for our clients, which makes our law firms flourish. It just was extraordinary. I can't wait to do the next one.
Well, and not just when they work on the strategy though, but when they weren't, so just helped better people's understanding. So there was 2 groups of 5 students. And so the 5 students that you were working with to work on the strategy of their cases, the other 5 students were working with myself or with Giorgio in a separate, kind of working on their performance skills, their presentation skills, their cross-examination skills, their connection skills, and, being videotaped, being coached, and getting a chance to practice their presentations and learning. And so we're doing and that one, you taught the second half of it. The first half was taught by Satch Oliver, and people were working on their depositions, our trial skills. And so we did the same thing with Satch for 2 days before you got there. And then the first day in the afternoon, we typically start on the first day in the afternoon from 2 to 6, we work on witness preparation and direct examination. So it's really about a 4.5 day program. And you have one, we're going to teach one together on spine trials, October 23rd through 27th. So it's going to have a little different pattern. It's going to be a Thursday to Monday pattern. I'm looking forward to that because in that one, again, it's just going to be about spine cases. And we're going to talk about in a second. You recently had a great verdict on a spine case that you were asked to come in and, co-counsel and try. And so basically, you're going to help with the strategy, and we're going to help them with the performance on their actual spine cases.
Right.
That's the way it's going to work the 23rd to the 27th. So,
I can't wait. And when you think about it, though, the foundation of what we do in virtually every personal injury or wrongful death case centers on proof and argument of damages. Yes, we have to prove causation. Yes, we have to prove underlying liability. But it all comes together in the damages presentation. The reason we're there is because of what happened to our client. Okay? And what we're going to focus on in the spine classes that we're going to be a part of when we get out there for the program, we're going to talk about every phase of it, what you need to do from day one. Most of these cases are lost because of what the plaintiff lawyer fails to do in the first 24 to 72 hours or that first 30 days. A lot of lawyers think, oh no, it's, what you're doing the week or 2 before trial. Forget the week or 2 before trial. I want to talk to lawyers. What are you doing the first week you have the case? Because if you're not getting the client to the right treaters, if you're not preserving the evidence, getting the 911 tapes, getting the nearby surveillance tapes, downloading the vehicle data, you're at a disadvantage. So I'm excited about it, can't wait. And spine, that's the foundation of what we do as PI lawyers.
I mean, everything starts with the spine. Every young lawyer, a spine case or a herniated disc case for a civil lawyer is kind of like the DUI case for the criminal defense lawyer. It's a place to go to trial, place where they're often not going to pay, just like they're going to, you're often going to, if you're a criminal defense lawyer, you want to get reps, do DUIs because they're hard as hell. And there's a lot of technical skills involved. The stakes aren't too high. So, if you lose and you mess things up like many young lawyers do because of nervousness or inexperience and their innocent clients get convicted. Yes, they say it's maybe a few days in jail instead of 30 years. And so, you know what I mean? And that's just kind of like, it's sad that, there's these collateral damage when you're learning to become a lawyer, but it's just a reality of it. And, as hard as we may work on so many things, there's no substitute for experience because you can't see what you don't,
Well, it's funny, Dan. I was sworn in May 10th of 1974 at 11 a.m. That was a Friday. The following Monday, I tried my first case solo. A partner in the law firm had said, I need you to try this because he had to go and try another case for a lawyer who got sick. And it was a civil assault and battery case, no discovery, no meds, no bills, no nothing. I would pick a jury, give an opening, put on one eyewitness, our client, rest. The defendant would put on two witnesses, rest. We argued. And to make a very long story short, the final offer going into trial from this lawyer, the defense offered $25. And the final demand from the lawyer in this firm, because the case was like a friend of a friend, they were doing it as a favor for somebody. His final demand, he had gone from $300 to $150 because it was a one punch at a party, no meds, no doctors, punched him. That was the case. And a senior partner had me ask for way more than I otherwise would have asked for. And I got a verdict of $2,500. And when I went back to the law firm, the door opens and it's like there was a receiving line, like I had just gotten $1 million verdict. They were all clapping and cheering. And that's what happened when I got my first verdict. The way they treated me, it was unbelievable. And I will say that was one of the greatest moments of my law life in terms of getting that. I know it's not the biggest verdict in the world, but it was like $1 million verdict. And the thing is, I think, okay, my most recent verdict was 3 or 4 weeks ago in a case where I had to pick a jury 3 times. And it takes patience. You say, what happened? First time we ran out of jurors because there were so many challenges for cause that were granted. 39 challenges for cause granted. All right. Then the second time, we had a juror blurt something out that the judge felt poisoned the panel, and he dismissed the panel. Then we had to pick the jury.
What did the jury blurt out?
Oh, I'm questioning, let's say, juror number 4, and juror number 5. He's got his hand up, and I said, I'm coming right over to you, sir. So I finished with her. I go to him. I said, all right, you had your hand up. Before I can even ask him a question, here's what he says. I'm a paramedic. I'm a firefighter. And you said this is an underinsured case against this insurance company. I'm here to tell you that I've followed on a lot of the patients that I get from these accidents. These insurance companies, like them, all they do is ruin and destroy people's lives.
Well, that's a true statement. So why did that how'd that contaminate the jury?
It is a true statement, in my humble opinion. But the defense raised an objection. The judge says, I don't even need to hear argument from the plaintiff. I said, well, Judge, please. So I tried. And the judge goes, because he's somewhat of an authoritative figure in the community, right, as a firefighter, a fireman, I do think he has poisoned the well, and it's contaminated to the point where I'm going to shut it down. So then we had to pick another jury.
Was that 3 separate court dates, or was this all right in a row?
One was in November, and then we broke till November. Till March. Then we came back in March. We picked a jury that Monday. That incident happened. Then the next day, we started with another jury. But before we got started, I said, Your Honor, this will be our 3rd time trying to get a jury here. I would respectfully request that any of the questioning about contacts that any member of the panel has had with this particular insurance company, that we bring them in separately so that whatever they got to say, they don't say it in front of everybody else. Because, look, people have strong feelings about this. Anyway, the judge said, okay. It didn't take that much longer to do it. We had a panel of 60, and there were about 25 on the panel who had insurance coverage with this particular insurance company. So we brought them in one by one. And, like one would say, I hate the insurance company. Another would say, I love them. Whatever, they've been great to me, those kind of things. The biggest thing I would say to lawyers, not just young lawyers, but even seasoned veterans, about jury selection, be patient. Don't try to rush it. Don't jump. And if you get a judge who says, I don't know, let's say you get a federal judge who says, I'm going to ask all the questions. I'll grant your motion for attorney voir dire. I'm going to give each side 15 minutes. Or you get a state court judge, each side gets 30 minutes. You should try to fight that. But if you don't prevail on that fight and you only got 15 minutes, you don't try to fit in 10 different areas of questions. You talk to a trial consultant, you talk to everybody on your team, and you say, if we got 15 minutes and we got a panel of, let's just say a panel of 40, we really only have time to develop one or two areas. Or you can do one of these where you hold up, a board, or you place the boards around and you say, I'm going to go right through. I'm only going to ask 3 questions. And all I want from each one of you is agree, no opinion, disagree. And I'm oversimplifying this. I wouldn't do it exactly like that. And then you go, okay, as to this question, pain and suffering is real. Again, that would not be the question I would ask, but pain and suffering is real. Agree, disagree, or neutral. And you ask them all. Mark Lanier does a great talk on this, of where he was limited by a federal judge. And he decided, since the judge is limiting me to 30 minutes, he told the jurors, I've only got 30 minutes. I don't have time to discuss all of the issues with you. So I'm going to hold up a question. And then I ask you, strongly agree, no opinion, disagree, strongly disagree. And he only asked 4 questions. And his 2 trial consultants who were with him, they all came to a consensus on how to do that. So patience is such a key. If you try to rush through it, you're not going to get anywhere.
And so this recent verdict you had on the spine case, give us a little insight on that. It was an underinsured motorist.
Well, it was an underinsured case where the lawyer who brought me into the case, he settled the bodily injury case for the policy limit. The policy limit was $500,000. So that was settled. And then he made a demand for the underinsured motorist coverage, which in Florida, it's $100,000 in this particular case. So he demanded that. Initially, they offered him $1,500. And a little later, they offered $50,000. So they wouldn't even offer him the policy limit. When he brought the case to me, I thought, well, gee, she had a 1-level cervical fusion and ultimately a low back laminectomy. So I thought, why is that case not worth more than $1 million? So if we got the $500,000, they should have ponied up the 100. That was an easy call. And it was a rear end collision. So clear fault, decent property damage. And she tells the paramedic, I have pain in my neck, pain in my low back. She gets to the hospital. She goes, pain in my neck, pain in my low back. She sees a doctor 2 days later, pain in my neck, pain in my back. So I go, why is that not a good case? And they had all kinds of issues. They were saying it's pre-existing. They were saying she's exaggerating. We had to watch 90 minutes of surveillance, 90 minutes. And I looked at the surveillance and went, I don't get this, because there was no smoking gun. It showed her doing things she could do, like go into a grocery store and shop, etc. Anyway, so the offer was $50,000, the final offer, and the jury verdict came back and it was $5 million. And so now we're involved in a series of post-trial motions.
Well, that's a nice result.
Yeah.
Only, 100 times the offer. That qualifies for, I think it's 100 times, 50,000 times 100 times is 5 million. So that's good. 100x the offer. Good.
Well, here's the thing though. If you have a good client, which we had, she was a good worker. She had been a gymnastics teacher, where she was involved in the physicality of teaching children. So when 10-year-old Sally would come running along and jump on the vault, she had to catch her until Sally learned how to do the vault without having to be caught. And the same thing with the young kids on the beams and the bars and all of the things they do in gymnastics. It's physical. And she has to show them herself how to do it. Now she's out of work. She can't do that kind of job. But as soon as she realized she physically could no longer do that, she got another job. So she's a good worker. So to me, it was a very good case. I still do not understand why they did not pay the limits very early to the lawyer who brought me into the case, because it was a very valid, legitimate claim, and they failed to pay it when they could have and should have.
Let me ask you, you've been teaching now for most of your 51 years. And so how did you get started teaching at trial lawyers events?
Oh my goodness. I laugh because we keep talking about how the stars have aligned in my life. When I came out of the Marine Corps and I go to work for this great law firm, when we get to around, I'd been there several months after leaving active duty. One of the senior partners who had just been president of ATLA comes in and he goes, "John, I need a big favor." I said, "Yes, sir." He says, "I am supposed to give one of the key speeches at the upcoming ATLA convention." And he explained to me his wife has set up a family vacation, which would not get them to the convention until a day late, the day after this speech. So he said, "I need you to give the speech." And it had to do with the crocodile case. He was going to talk about that. And I said, "Yes, sir, I'll do it." What I then learned was the program was going to be the Sunday program. It was called the Tort Idea-a-thon. The two moderators were Melvin Belli and F. Lee Bailey. At that time, the two most famous lawyers on planet Earth. And then I found out that the two speakers just before me were going to be Richard Racehorse Haynes, the famed criminal defense lawyer from Houston, Texas, and Mark from California. Mark had just gotten the verdict in the Ford Pinto case, and Mark got a $128 million verdict. So they were going to be introduced.
Mark Robinson, just to help you out.
Yeah.
Remember. Yeah, okay.
And Mark, it was an incredible verdict. And so when I'm sitting there, F. Lee Bailey introduces Racehorse Haynes and goes on and talks about all of the great things he can about him. And he gives, it was a 15-minute speech, and he finishes. Then Melvin Belli introduces Mark Robinson and goes on about this great, great lawyer. Then he looks over at me and he goes, "Come on up here, young fellow." And he goes, "Go ahead, take it away." He doesn't even introduce me.
He didn't know your name.
He didn't know my name. And I had decided it's not like I can lecture the people in this audience. So I decided to give the first 15 minutes of the opening statement from the crocodile case, which is a very compelling, emotional story, and it needs to be told in the right setting at the right time. But in an auditorium like that, that was the right setting at the right time. And it went over very well. And then immediately I was invited to do a number of presentations in different states. And I was on the national speaking tour at age 28.
And the rest, as they say, is history.
It
Because
was-
you have probably taught at more CLE events over the last 47 years or however many years than any other lawyer in this country. I'm certain of this in that time frame.
Maybe, but I love it. The teaching, the seminars that I went to as a young lawyer were just beyond spectacular. It's an amazing thing. Dan, when I was in the Marine Corps, this was in 1976, we were summoned to a seminar at the Officers Club. We all went, and I'll never forget this major got up there, and he is at a lectern, and he starts reading about the statute, basically the Uniform Code of Military Justice. And he's just reading the statutes. And I went, oh my God, get me out of here. As soon as that program was over, we go back. I was with the 2nd Marine Division Headquarters Battalion at Camp Lejeune. My colonel, he's called SJA, Staff Judge Advocate. That's like the the DA of a given community, your district attorney. And I'll never forget saying to him, Colonel Bailey, I would love to have your blessing to contact a national organization to bring them in with some of the great lawyers to provide a big seminar to JAG officers from all over the country, and we'll invite them all right here to Camp Lejeune. He wanted to think about it. Then he said yes. And then he said, we have to get permission from our general. We went up, I made a presentation to our general, McClellan, and he said, okay. And then we had to travel to Washington, D.C., Colonel Bailey and I, to get the blessing of the then Staff Judge Advocate, Judge Advocate General for the Marine Corps, which actually was called the Director of the Judge Advocate Division. He said yes. So in 1976, I had made a call to, guess where? ATLA. And I spoke to the then CLE director, a guy named Mike Canavan. And I said, here's what I got in mind. He goes, let me see if I got this straight. You want me to round up some of the greatest lawyers in America and bring them to a Marine Corps base. And you're going to bring in JAG officers from all over the country. What can they pay? I said, oh, well, they can't pay anything. We don't make a lot of money. He goes, oh, so we're going to do the seminar for free. I said, no. What I would ask you to do is not only do the seminar, but provide a 1-year free membership in ATLA for every attendee, because a certain percentage of them, once you grasp them and they see what ATLA is all about, they will stay members their entire lives. Dan, that is what happened. And they brought in F. Lee Bailey, Racehorse Haynes, Melvin Belli. They brought in Henry Rothblatt, who represented Colonel Henderson in the My Lai massacre case. They brought in Harry Philo, the great product liability lawyer. You know all about Harry from up
Detroit.
in Detroit. They brought in Bill Colson. They brought in, her name was Amelia Lewis. Amelia Lewis was from Arizona. She is the lawyer who argued N. Ray Galt in the U.S. Supreme Court. N. Ray Galt was ancient history to you, but to me, it was a big deal because that's the case that gave certain rights to juveniles who were charged with crimes. So it was beyond exciting. So once we got it all together, our colonel is getting kudos from the general, from the Pentagon. Our colonel is just loving it. And he then calls me one day and he goes, John, we have a request. They want to do a banquet during your big seminar, and they're going to bring in the Marine Corps band. And the band actually plays at banquet type events like an orchestra. And so it was crazy what happened. And so from that, we formed the initial Camp Lejeune Cherry Point Trial Lawyers Association. And I'm sad to have to tell you that after I left active duty, the people that I had hoped would keep it going didn't.
They dropped the ball.
They just didn't, and it was too bad. But it turned out to be a fabulous seminar, and we actually did it 2 years in a row, 76 and 77. And then they did do it one more year, but then never again. But it was huge because you brought in hundreds, and there were Army lawyers, Air Force, Coast Guard, Army, everything.
The highlight of TLU for me was having the opportunity to network with with attorneys from out of state.
TLU has been amazing. I'm so glad I came. It was one of the most inspiring events I've been to. Great networking, great food. It's been amazing. I can't wait for next year.
Speaking of conferences, you're going to be coming to Huntington Beach this year, June 4th through 7th for the 4th annual TLU Beach event, and which happens to be my favorite conference ever. And for the reasons, because we have the whole hotel. So we bought the whole hotel. It's on the ocean. Every room has an ocean view. There's 4 lecture tracks, 8 workshop tracks, theme parties every night, full breakfast, full lunch for everybody. And then even after the theme parties from 5:30 to 8:30, ping pong, air hockey, and foosball, DJ, and open bar. So it's super fun, super learning. There's, in these breakout rooms where there's workshops and there's master classes. And so you're going to be doing a couple hours of lecturing and a 1-day spine trial class on Friday, June 6th. So let me ask you, John, you were at Huntington Beach. Did you?
I was, yes. I was there
Huntington Beach last year. You missed Vegas because you had some case or something like that, supposedly. But anyways, Huntington Beach. Let's talk about what you're going to be teaching there. So,
well, we're gonna do in terms of what I call your tutorial workshops.
Master class, spine. We got master. Hold on, just so people could clear. We got Nick Riley teaching a 1-day TBI master class. Connell Doyle, your friend, and who's friends with a lot of your family members, and your other friend, Sagisha Ked, they are also teaming up to teach a TBI masterclass, but that one's going to be more from intake, identifying the case, working the case up, working up the depositions, doing all the stuff really before trial, whereas Raleigh's going to focus more on trial. So there's kind of 2 different classes that kind of work together, because that one's going to be on Thursday. David D. Robertus is doing a 1-day employment class on June 7th. Dale Gallipo, 1-day civil rights master class on June 7th. And if people want to just go attend those classes, they could buy just a 1-day Saturday ticket to go. And Chad Dudley and Steve DeBosier are doing a 1-day business operations master class on June 7th. Kurt Zahner's doing a premises liability master class. Ben Cloward, negligent security. Michael Hill, elder abuse. So for anybody that wants to really dig down, and I'm sure I missed one or two, and really focus on their skills in a particular area and build a little mastermind group, network group that works on those kinds of cases, this is their opportunities, all I can say, to really learn, because these are smaller classes, maybe 10 to 15 people, and really, getting into the different aspects of it. So just so everybody clear. So first, let's talk about, you're going to be talking, your presentations are going to, and the lecture base are going to focus on, articulating and communicating the damages aspect of these trials. Could give us a little more insight on that.
Yeah, the big thing about the spine injury cases is it's not what happens in the courtroom in terms of what you say, what you think you're saying. The only thing that matters is, what is the jury hearing? What is the jury seeing? What is the jury perceiving? That's the key to victory at trial. So what we're going to focus on is how to gather all of the necessary ingredients so that you have it all together to follow your recipe. Okay? Much like a cooking. You got a recipe, now you got to follow it, but you got to gather the ingredients. And the ingredients have to be in accordance with that recipe. So what I want to do is make sure that everyone understands how we gather that. How do we gather the evidence? What we do way in advance. I'll give you an example. You can't show up at trial with big boards or slides showing pain scales if you don't have a doctor who ever said a word about them before the trial, either in his or her records or in deposition. It doesn't help you. So I know this, when a client comes in to see me, I'm thinking trial already. I'm thinking pain scales. I'm going to meet with that doctor early, the treater, and say, I need you to incorporate pain scales into your medical records. And then they do. And then that becomes a part of the medical records. That's a natural thing for a doctor to do. I want to make sure the lawyers in this class understand the medicine, understand the anatomy, but most importantly, how to communicate with the doctors, what to do when you're preparing a client for direct examination. If your client takes the stand and does not know the language of the case, shame on me as the lawyer. I'm the one who has to teach that to the client. When we're sending a client into a defense medical exam, you can't just tell them in 10 minutes, well, just relax, tell the truth. There's more to it than that, because you got to tell them, look, the doctor is going to say, are you in pain in your neck area? I don't want you to just say, yes, my neck hurts. I want you to be able to describe it. So what we're going to do is teach everyone what is the language the client needs to use to describe it. Excruciating, unrelenting, whatever the words will be. There's so much more to it. And I hear all the time, talk to clients in cases. Yeah, my deposition was taken. The lawyer showed up about 30 minutes ahead of time. Stanley Prizer used to talk about how when he did a pre-deposition conference with a client, he spent an entire day with them. That's important. It's not a matter of just showing up at the last minute and doing it. So we're going to talk about how to do that. And then how do you translate what has happened in the courtroom into dollar amounts? What are the techniques of doing that? When do you do it? Why is it often fatal if you have a number in mind and you get to final argument and you go, okay, now please award $1 million. And the jurors are stunned, they're shocked. They have sticker shock. It's because you brought it out at the wrong time and the wrong way. There's a way to do it. I don't care what state you're in. There's a way to do it. Anyway, we're going to talk about all those kind of things, Dan.
One of the things that you have on your agenda to talk about is conducting the OSPA, Opposition Strategy Prediction Assessment. What is that all about?
It is where you take each phase of the litigation and especially trial, and you do a complete assessment that you put in writing as to what the defense lawyer is going to do. Example, we're getting ready for trial. I will say to one member of the team, I need you to prepare the defense opening statement. One thing that I love about jury research, focus groups, mock trials, even big data gathering, is it forces you to prepare both sides in most instances. But I want somebody on my team to prepare the defense opening statement. Somebody on my team must prepare the cross-examination of each of the different witnesses that will be the cross we're going to get from the defense. And it's not by just sitting down and go, oh, I think they'll ask this, I think they'll ask that. We get transcripts of the defense lawyer we're going up against from his or her recent trials, not some trial 15 years ago, on what did they do in voir dire? What did they do in opening? I've got a trial coming up in October. I've already got probably 5 sets of transcripts on the defense lawyer. Every single trial, his voir dire, this is great. He's just using the same outline, even though the facts are different and everything. And then what he'll do is at one point, he'll shift gears and he'll insert truck instead of car or product or whatever it is and make a little bit of a change. Other than that, the voir dire is identical in every single one. One thing that he does, he also talks about his family and his kids and all that. All right, good. I'm ready now with a motion in limine to say, no. We can't be doing that, because as soon as you do that, then everybody's talking about their families. And, they say, well, I was talking to my son last night as I was rubbing his back and saying a prayer to him when I put him down to bed. You can't do that. Come on.
That would be inappropriate.
It would be inappropriate, but I've seen people do it,
Oh, yeah.
My daughter came up to me. Gary Pillersdorf used to tell a story to juries. He said, last night my daughter asked me, Daddy, what are you going to ask the jury for? And I said to her, well, what do you think I should ask the jury for? Anyway, it's a lengthy discussion that he.
Well, that seems appropriate in closing argument, but not in an opening state, or not in voir dire. But I mean,
yeah. Anyway, it'll be interesting to see how it goes. But an OSPA is that you're taking every step of the way and trying to predict it. A very important thing to do is when a defense lawyer is going to take your client's deposition in any personal injury case, get transcripts on that defense lawyer, because they tend to use the same outline on everybody. If I have an accident reconstruction expert and John Doe, defense lawyer, is going to be taking my accident reconstruction expert's depo, all I got to do is get a couple of 3 transcripts of him deposing other accident reconstruction experts. It's the same outline. It doesn't change with most people.
I couldn't agree with you more. And I mean, because that way you can properly prep your plaintiff for the defense medical exam, because the questions that are coming. So it lowers their anxiety for it when you're like, this is what's coming. Because it's been great when they get out of it. They're like, oh, that was nothing compared to what you put me through.
But by the way, Dan, you mentioned Segee, who'll be speaking at Huntington Beach, and you mentioned Connell. All I can tell you is I knew each one of them truly as baby lawyers. Connell at one point was roommates with our son Eric in law school, and I knew Segee right from the start of his career. And it has been really, really wonderful to watch them develop into 2 of the greatest lawyers in the country, each hitting not just one home run after another in the courtroom and with settlements, but hitting grand slams. Nick Rowley, I knew from the beginning. I not only have read everything he's written, but I've read all about him. I've heard him speak many times, but I was in a courtroom in Indianapolis, probably, I don't know, I'm going to say it was about 6 or 8 months ago. And the judge actually took us up to see the bigger ceremonial courtroom, because that's where I'm going to have a trial later this year. We go walking in, who's in trial? Nick Rowley. And I get to watch him for a little while. He's from another planet. He's so good. He just is. And that doesn't happen overnight. That happens not only because of your persona, but the way you are, the experience that he's gained. And he was so natural, just the flow of everything he was doing, the way he was with the judge, the way he was with the jury, the way he was interacting with everybody. So I don't know, it's really fun for me to see lawyers that I've seen as brand new lawyers and the way they have grown and developed into these just extraordinary advocates.
That was on his Tesla trial that you saw there that was actually televised on CVN. And it was the first trial televised in Indiana on CVN. And he got a real nice verdict on that one. And we did a case analysis on that one, which happens to be on TLU On Demand in case you missed it. My goodness.
There you go.
For trial. It's an app for your phone. You get all the pleadings, transcripts, and PowerPoints. It's just I think it's a great resource, but of course I could be slightly biased.
A little bit.
But if you don't have it, if you shoot me an email or text, I'll give you a complimentary access so you can try it out.
And so you have to practice in the deposition. You practice in motion hearings. You practice at the grocery store. That's why you have a family. You practice on them. You have to keep the skill up or it erodes. It's simple as that.
Somebody give us an overview of this case.
Or I call wowing it. And what I mean by wisdom of the wise is, why are we still right in spite of this fact?
These are just some of the clips when I was prosecutor 10 years ago, remember that.
About 11 o'clock at night, and he leaves this message. I got a brilliant idea. Every conversation he starts, I have a brilliant idea.
But welcome, everybody. We've got a good crowd here today.
how do people get a hold of you? Because we got some more to talk about, but you never know. So how do people, they need John Romano, need some questions on spine, pain and suffering, have
You come directly to me. My cell number, 561-346-5090. That's 561-346-5090. And my email, john@romanolawgroup.com. And that's John at Romano, ROMANO, lawgroup.com. Cell phone's always with me.
I know. And it's always got a new message every day.
Every day.
Good morning, everybody. Today's May 5th, 2025. It's Monday. I hope you're having a great day. And I'll be in depositions all day. So if you'd like me to get back to you, please leave your name and phone number. And I'll get back to you just soon. Every day, a new message. The only person I know records a new message every day of their life. That's
part of my early morning wake up routine.
That's a good thing because it feels fresh every day. Everybody always has to worry about their messages getting lost in the I don't know, wherever messages get lost in voicemail. I don't know. People don't check it. But let's see. That wasn't when you were at my boot camp. That wasn't because you were actually at one of my earlier Trojan Horse programs back in West Palm Beach.
I
said, John, you got to come down and see this great program we're doing. I'm like, okay, we're at some little hotel. I can't remember what it is, but back with I think Tim Felice was there too, because actually I have a podcast with Tim Felice because he's one of the greatest, resilient stories and journey to become a trial lawyer stories ever. Because that guy's taken a lot of blows to the head, but he keeps getting up and finally hit pay dirt.
Tim is not only is a great lawyer and a great advocate, but he is a great person and he is a team player. And I can tell you, when people call upon others for help, like FJA or AAJ or these organizations, we need help. You go to Tim. Tim is always there. Hey, I'm in for the fight. What can I do? And it's never, a series of excuses. It's, I'm with you. I'm there and I'll be on the front lines with you. But he's amazing. And he just got an extraordinary jury verdict in a small town way up north in Florida, in a very, 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 very conservative community. And the verdict was like $86 million or something like that. And I'm just
or 92.5
or 92.5.
Not that anybody's keeping track of $1 million here, $1 million there.
But we are so proud of him. He just is amazing.
I'm so happy for him too, because he's faced a fair amount of setbacks, as most of us have, but you get set back a couple times in a row, starts to affect self-image. And we all know how detrimental is that when a lawyer's self-image get dented a few times.
I know.
It can start to set you back.
I'll tell you what, though. I spoke to a lawyer who you and I both know, but a great lawyer in this country who lost a medical malpractice case recently. And I called him up as soon as I heard about it. And I said, just remember what I always have taught you. When you get a verdict, you have till midnight to either celebrate or to sulk. And once the clock strikes midnight, that verdict is history. Stop the celebration and don't live off one verdict for the next 10 years. And if you lost, don't be down in the dumps, because your clients need you, your family needs you, your friends need you, your staff need you. You got to press on. And it's so important because, I know of one lawyer who got a verdict, God almighty, I'll bet it was 30 years ago. And it wasn't even I'll be careful how I term this, but
it wasn't a real verdict. It was a prove-up verdict on damages that wasn't defended.
Yes.
We know lawyers that do those kinds of cases and brag about their results.
Okay. Well, I understand that can happen. You might have a carrier just deny coverage when they shouldn't. And so you got a default and you go try it, but you don't brag about it on your website. And this is a lawyer who for 30 years is saying, well, and the way I molded the jury. Come on, there's nobody in the courtroom to stop you from doing anything. And the trial took 3 hours. So to me, it's really it's important that we're doing it right. And, you mentioned case analysis. When you started doing that, I will say that to me has been one of the most innovative, creative tools to make us better lawyers in the history of CLE in America. And all you do through TLU is you take it to a totally different level. And it's extraordinary. And Dan, I will say, to talk about you for a moment, your creativity, your innovations, and the way you have been a visionary in this field is making a huge difference to all of us. And that's to young lawyers, to older lawyers, to everybody in this field. It's extraordinary. And I love what you were doing with Trojan Horse when it got to case analysis. That's something you can continue to do forever. And then with TLU, just extraordinary. It really is. And you make it fun, which is all the better.
Oh no, Huntington Beach is the most fun conference ever, because even like things before the conference, with the workshops though, every workshop instructor has to have 2 Zoom meetups with their classes ahead of time so people get connected before they get there and get to meet each other and asking, and everybody does personal bios, the story of who they are written in the first person. So that goes a lot, to me, that goes a long way to the fun, because you have fun when you have friends. And the more people that you know and the more you know them, the better it is. I mean, the better it is for the fun, the better it is for the business, because nobody collaborates on cases with people they don't know or people they don't like or people they don't trust. And you can only know, like, and trust somebody if you have an opportunity to actually really spend time with them. And, and that's why we have an hour and a half breakfast every morning, an hour and a half lunch, so people can sit down, relax, don't have to go hustle and run into a restaurant and be stressed for time and, shoveling down food and not get a chance to just relax and just have some fun, because this is a hard job. We got to have fun when we can.
Oh, yeah.
If we can learn and have fun and make friends, it's like a super triple win.
Oh, it is. But what happens is when you do these programs, whether you're an attendee, a speaker, a moderator, just being there, you're meeting new people. And when you get lucky, some of these new people become some of your greatest friends for life. And I think of so many people that I've met at these meetings where Nancy and I, our kids and their wives, our grandkids, we've become great friends for life. And we start doing things together. And then you create network upon network upon network. It's phenomenal.
I'm really looking forward to it. John, you've been doing this for 50 plus years. What would you say is your greatest accomplishment professionally?
Professionally, clearly it is in the teaching, the motivating, and trying to inspire others to where we all do better, trying to motivate lawyers to have an eagerness, a hunger to get better. I remember in law school talking to a lawyer in the community, and he, funny kind of way, commented that he hadn't opened a law book since he got out of law school. And I thought it was funny until a few years later, I realized how sad that was. Because if I'm a doctor, I want to be a scientist forever. If I'm a lawyer, I want to be in the law, immersed with the law in many ways forever. And that is so important. So if somebody were to say to me, what's been the most important thing to you in the law throughout the time of your calling as an advocate, it would be really in the teaching. I'm still trying cases, just tried another one a few weeks ago, got another one coming up in a few weeks, and then 3 more this year. One will absolutely go, the others I don't know, and I will keep doing it forever. I will never retire. I want to do this forever. People laugh. I do keep telling people I intend to live to be 150. I'm hoping they come out with with the right pill or medicine or, some kind of special iced tea to keep me going forever, because they would have to drag me away from this.
I hear you. I can't imagine retiring. I can't imagine not having anything to do every day. I remember you saying, You know, we talk about pressure at these events and stuff. You're like, Dan, pressure is a privilege.
It
You got
is.
something pushing you every day, something important, something that people are counting on you to deliver. That
It
is a
is.
great privilege because,
Oh,
and
it
it's so
is.
right. Because
No,
imagine,
Dan, I tell people, I say, if you don't like stress, don't be a trauma surgeon. If you don't like stress, don't be a police officer walking the beat in downtown in a big city. If you don't like stress, don't be a trial lawyer. Okay? There are other things you can do. You don't want stress, there are other things you can do that don't have stress.
well, I think stress might not be the right term, John, because pressure is different than stress. Stress
Right.
is, I think, the result of inaction. When you have obligations and you're not doing them, that's where stress comes from. When you have obligations, you're putting everything into them every day. There's no stress because you're doing everything you can to, make it happen to get to the finish line. So, anyways, on the stress part. Now, John, you have a unique situation because you have a couple kids that are also lawyers that you work closely with too. So, what has that been like
Oh,
to
yeah.
have a
Well, I mean, gee, it makes it all the more enjoyable. Eric and Todd have been practicing with me, with us. It seems like forever. But when Eric finished law school, he became a prosecutor for 4 years and then came with us. When Todd finished law school, he did Marine Corps JAG. And after 4 years in the Marine Corps, he came with us. And they're both active practitioners, trying cases, taking depositions. We have a number of cases where we're working on them together. Some cases it's myself and Eric or myself and Todd. Many others, the two of them work together. And then there's a few where the three of us work together. But we're all a part of this. We teach together, we lecture together, and we just have a great time. And my wife, Nancy, who, as you know, Nancy and I are together all the time. Nancy.
When's the last time you were at a CLE where Nancy wasn't there? I've never seen you at one without her.
It has been a long time. I can't think of one in the last 20 years.
No, I can't think of one.
When the kids
I've known you, I've never seen you without her.
when
So
the kids were little, there were some occasions, but even then, I tried to bring Nancy and the kids with me everywhere. It helps to, from my perspective, the greatest thing is in life is to be in love with somebody you adore. And that's how I feel about my wife, Nancy. And I don't ever like being away from her, ever. And,
I noticed that. I noticed that. I noticed that. So, John, there's a lot of young lawyers out there. Somebody said they want to become a trial lawyer, and they said, Mr. Romano, give me some of your words of wisdom because I got no fucking clue what's going on in this world. I just got my bar card and I'm terrified. And there just seems to be so many different directions to go. I don't know where to begin. So where would you recommend that a young lawyer fresh out of law school with his card wants to become a trial lawyer? Where did they get started?
If I had the undivided attention of that young lawyer, so I got a man or a woman standing in front of me, I put my hands up on that young lawyer's shoulders and I'm looking eye to eye into his or her face, I would say something like this. I would say, theoretically, you want to live your life so that when you get to the last 30 seconds of your life, and somehow you have 30 seconds left, and you're looking towards the future, you want to stop, do an about face, and as you look over your life, there's only going to be one question. What have I done for others? And I would say to this young lawyer, the beauty is you have that entire future ahead of you to be able to think about how you're going to answer that question. I would say, follow your heart. Do what your heart is telling you to do. Wherever you go to work with people you enjoy being around, who you trust, who you admire, who you look up to as mentors. Work very, very hard Hard work is therapy. It's wonderful. And I would say, as you are doing this work, always be thinking client, 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 client. Because if you always are thinking, whatever I'm doing, how does this affect my client? You will do the right thing. If you let your ego get in the middle of it, or you let firm finances get in the middle of it, so that you settle a case quickly and for a little less because the firm needs the money. No. You're not helping that client. You got to push and push. I'd tell them something like that. That'd be my message to him, Dan.
All right, some solid advice. All right, John, we're at the end of our time here. So we always end these days with cross-examination 101. So you may have seen some of this before, but repetition is the key to all learning. That's what I've heard. And so I always like to end my podcast with this cross-examination of the defense medical expert, because out of all the things that, I've been involved with developing over the years, which, top things I think are witness preparation. People used to tell me but I used to do a lot of that before the pandemic. I don't do quite as much now, but I started doing it again. I'm actually going down to Angel Reyes' law firm down in Dallas. They got a pretty good sized firm. I think about 40 lawyers. And I'm going down there in May 22nd and 23rd and doing a 2-day witness prep and direct examination workshop for about 20 of their lawyers. Because I think that's the most important thing a young lawyer can learn, is how to properly prepare their plaintiff or their client for deposition. Because the client does way better in deposition. So the case is, if it's going to settle for more money, because the defense lawyer is going to tell the adjuster, hey, man, I really believe this guy. I like this guy. This is 25 grand. It's a 50 grand policy. We need to, pay this so we don't get, dinged on bad faith. And it also really lets that young lawyer learn how to get the client's story, so they really can connect with what happened to that person that got injured, instead of just like, oh, just another docket entry. Oh, we got to do this. We just got to, here's a little form. Here's a little video for you to watch to prepare for your deposition, because it's just a little case. Well, it's not a little case to that client. It's their only case. And so I think that's a really good place to get started. And then right after that, taking depositions, learning deposition skills. But one of the skills that people should be practicing every day in their depositions is their cross-examination. I know on quote unquote, it's a discovery deposition in most places, but you're also looking to get sound bites, but you also have a chance to practice your skills as a trial lawyer. When I used to be a criminal defense lawyer, a young one, I would take every case to preliminary exam. I didn't care how overwhelming the evidence was against my client, because the prosecutor would be like, why are you wasting our time? I'm like, I'm getting practice, and I know how to get practice, and I have evidentiary hearings just to get practice my cross, practice my time in court. So you got to find opportunities to practice, and I think depositions are a great opportunity to practice our cross-examination skills. And, and to get better at them, you got to read people's depositions who know what they're doing. Like I read Brian Panish's depositions, and I get, much instruction from them, how he handles the non-responsive answer. How he smashes that expert who tries to be non-responsive. So he teaches them in deposition, answer my question or it's going to be painful. And by the time he's trained them through deposition, they fall in place in trial. But anyways, cross-examination. So John Romano, the core skills of have you seen my cross-examination of the defense medical expert, the updated one?
Yes, but a while ago. I want to say It was about 4 or 5 months ago.
Well, it's evolved since then, and as we say, the repetition. So I think the core skills, because people talk about cross all the time at a lot of conferences, and they are never talking about skills. They're only talking about strategy, how to set up a question and stuff like that. And again, but they never talk about the skills, whereas the skills are, the fundamental skills of all cross, I think, are, and now there are exceptions like leading questions only. One new fact per question. So basic, yet I watch lawyer after lawyer, even skilled, experienced lawyers, violating those 2 basic rules. And then they go and get a run-on answer for 2 pages from the witness because they basically invited it. Looping, to establish a fact and repeat that fact in the next question. I was watching Dale Gallipo, a great civil rights trial lawyer, last week, and every question was looping, constant looping. So I was, happy to see that, because he's teaching the jury, right? Speaking and asking questions in the present tense. Very few lawyers can do this. But if we train ourselves to speak in the present tense, even during cross, now some people work on that during opening and closing, which is good, But even during cross, because it forces the cross-examiner to picture or imagine what they're talking about, forces the witness, and most importantly, allows the jury to visualize the story that's being told. Dropping the taglines like right, correct, isn't it true, true. Dropping all the filler words like and, so, okay, etc., because people can't handle silence. Effectively using a flip chart. And what do we mean by that? We mean putting the writing legibly and putting one topic per page. Most people don't use flip charts at any time in trial, but it's especially important during cross-examination. Especially my buddy Orlando de Castroverde just got a nice like $1.7 million verdict on a non-surgical spine case a couple months ago here in Vegas. And we were practicing and training beforehand. And he comes over and practices at trains, on a somewhat regular basis. But he was like, Dan, the flip chart, first time I've used it in trial, it was just a game changer for smashing the defense expert who was a complete liar. Being intentional with our emotional state. I think there's really two dominant emotional states in cross, and they are not anger and frustration. If those enter you, it's like you've given the witness a little remote controller and a chance to push buttons and you just react, right? That is not good. It's curiosity when we're laying foundations and disappointment when we're either impeaching or showing bias. Those two emotions should be about 98% across, in my opinion. Training ourselves to speak more slowly. If you watch Court Review Network, there's a notable pace difference between people on their directs and on their crosses. And people tend to get amped up during cross, somewhat aggressive, and speak rapidly, and tend not to breathe too, which is so important, is to continue to breathe, because without oxygen, we're in big trouble. And then finally, bringing the jury in when appropriate. When I say looking at the jury and asking your questions, some people are comfortable asking all their questions to the jury. I'm not. I think when we turn to the jury and ask a question, it should be something significant that says, warning, take note, people, remember this fact, because this is something that's important, because I've looked at you and said it to you. So those are the core skills. All right, Dr. Romano. So we're going to demonstrate this. You're going to be the doctor. I'm going to question you. And for the purposes of this demonstration, you just basically say yes. I know that that's not totally real. I know some experts can be difficult, but this, again, training patterns, though. In training, I think it's important to train patterns, so that way the lawyer training gets the reps. And then once you have the reps and because we're building skills here, skill building requires repetition of the same movement. And so if that's why we don't train on people's cases, we train on set pieces. So there's repetition of the same story, the same cross, the same direct, so people can learn the skills from the people that came before them. Does that make sense, John?
It does.
All right,
yes, indeed.
Here we go. All right, great. Here we go. Doctor, you're a board certified medical expert.
Yes, I am.
To become board certified, this requires advanced education.
It does.
This education takes place both in medical school and after medical school.
Yes, it does.
While you were in medical school, though, you did take classes.
Yes.
And one of the classes that you took was on how to conduct a proper medical evaluation.
Yes.
Okay, so let's take a look at segment one. Obviously, looping. Every sentence begins where the last sentence ends. And one new fact per question builds upon itself. And you can see my pace is intentionally a little bit slower. And sometimes some people say to me, well, that looks really mechanical. You're going so slow. I'm like, well, if you read anything on training and skill building, they'll always tell you when you're training, slow down. Feel every part of the movement, because you can always speed up. And let's just talk about, and everybody speeds up with the pressure of the courtroom, or every human that I've seen speeds up under pressure of the courtroom. So that's segment one. Now segment two. You're trained, when I say segment, I'm just saying for purposes of training, to practice this part, skills over and over, then we practice this next part. You're trained that a proper medical evaluation, it must be impartial.
Yes.
So now I would have a flip chart behind me. I should have set up, I don't. And the first page is blank. So I flip that page over. And then on the top of the second page, it says proper, and it's underlined. I put number 1, and I have impartial written in capital letters. Then I put a number 2 underneath it, causing the jury curiosity, because there's more coming, because we have to constantly keep our jurors engaged. Doctor, by impartial, what we mean is that you're not an advocate for either side.
Correct.
Doctor, you're trained that a proper medical evaluation must not only be impartial. Now I turn, I look at impartial, and use my hand to point to it. Then I come back to the witness, but it must also be objective.
Correct.
So then I write objective on number 2, and I put a number 3. And of course, because I use parallel structure, which helps the jury to learn, now I'm going to define objective for them. Doctor, by objective, what we mean is that you don't cherry pick the evidence to support a desired opinion.
Correct.
Doctor, you're trained that a proper medical evaluation must not only be impartial and objective, but it must also be complete.
Correct. Yes.
So then I write down complete on the bottom part of it, and I also space out my impartial, objective, and complete to take up the whole page. By complete, what we mean is that you consider all relevant information.
Yes.
And so when I say what we mean is what you and I mean in the context of this jury trial, because complete means something very different in life, or impartial means something different when it comes to judging a ballet contest or a football game or a pie contest. So I define the term, and we come to agreement what these terms mean in the context of a courtroom. So now we go to the opposite. Doctor, the opposite of a proper medical evaluation, one that's impartial, objective, and complete. Well, that would be a biased evaluation.
Correct.
Doctor, you're trained and you know that there are certain risks associated with a paid expert's choice to conduct a biased medical evaluation.
Yes.
One of those risks is that the jury could be misinformed. That's when I turn to the jury and give that piece to them about the patient's condition.
That is true. Yes.
So now I flip the page over. It says biased at the top, and I put number 1, misinformed, and I put a number 2. Doctor, you're trained and you know. And that's an example of stepping. You're trained and you know. So it's like a universal truth that if a paid expert chooses to conduct a biased medical evaluation, not only could the jury be misinformed about the patient's condition, but they could also be misled. So I look to the jury and say that part too, as to the extent of the patient's injuries.
That is correct. Yes.
So then I put misled under number 2, and then I got number 3. Doctor, you're trained and you know that if a paid expert chooses to conduct a biased medical evaluation, not only could our jury be misinformed about the patient's condition and misled as to the extent of the patient's injury, but perhaps worst of all, they could be deceived into undervaluing the human harms and suffering that were caused.
Yes. That could happen. Yes.
So then I write down deceived. So we have misinformed, misled, and deceived. That's another example of stepping. Our person is much more likely to believe that a person would be deceiving if at first they believe they would be misinformed and misled. So that's an example of stepping. If we come right up to deceive, that a doctor is going to deceive, it's going to be harder for a jury who's built to trust doctors to believe that they're actually going to intentionally deceive. Now, misinformed, that's not so bad. Misled's a little worse, but deceive, that's pretty bad. That's real. As Snapshot would say, that's bad. That's real bad. You've heard him say that before, right?
Yeah.
That's bad. That's real bad. So now we come to the conclusion. Doctor, let me ask you this question. Or can I ask you this? That's called the refocusing move. So it's like squirrel, like the previous 20 questions I asked were all to get to this goal fact. So I think every chunk or every chapter, however you're going to term a subject or whatever you call it in cross-examination, I call it chapters because I read Roger Dodd's book and Posner's book about 10 times on the chapter method, should conclude with the refocusing move. So let me ask you this question. On December 14, 2020, you had a choice to make. So tell us all, what did you choose to do? Now, it's a specifically ambiguous question. So any expert worth his weight is going to act confused. I'm like, what do you mean? So could you be a good expert and just ask me what I mean by that?
Yes. What do you mean by that, counsel?
What I mean is, so that's called the spontaneous loop. So whatever they say at the end, you just take that and begin with it. So it gives it more credibility because you're using their own words against them. What I mean is, did you choose to do a proper medical evaluation? One that was, now I get to flip the page back over because I was on biased, one that was impartial, objective, and complete, like you were trained to do? Or did you choose to violate your training and conduct a biased evaluation? And I flip it back over, knowing all the risks.
I feel ashamed and humiliated, counsel.
You're going to fess up, are you, Dr. Romano? You're a paid whore. I like it. Not many doctors are that honest, so they want the jury to think that they're truly a neutral advocate, but I love
that question. Wow.
Oh, of course they were going to say that, but here's the beauty of it, John.
Right.
Is that in the 50 years you've been doing this, how many defense experts, whether medical or any kind, have you ever said, would you ever actually say we're impartial, objective, and complete based upon those definitions?
Oh, I don't think I've ever seen one.
Right. Maybe one. And so by doing this, they're saying this, but they're lying through their teeth because they do cherry pick the evidence. They didn't consider it all because they weren't given it all. And as soon as you get on cross-examination, that's where we're going to see the advocate pop out, right?
Yeah.
Where they don't answer our questions. They argue everything. You ask them a simple question like, what do you mean, Mr. Romano, when you say, did you do something different? I don't understand the word different. Like they do is the dumbest, like, I don't understand or you know what I mean? The stupid shit that they say and do. Or like you ask them a question, a simple yes or no, and they turn to the jury and they go on for a minute and a half, hoping to distract them. And, and that's what they're trying to do. Anyways, so it raises the cortisol of the expert and it can be adjusted for any kind of case. Let's say it's a biomechanic expert. Impartial, objective, and complete, still the same. But the difference is now what are the risks involved? That the jury could be misinformed about the forces involved. And if they're misinformed, they could be misled as to potential for injury. And if they're going to be misinformed, then they could be deceived into truly undervaluing the human harms and suffering that were caused. So, I mean, you just adjust and can mix and match. So it's really designed to be a template to be adjusted based upon the lawyer, their comfort level of certain things and the expert they're crossing. But I got to start somewhere. People are like, oh, I don't like to have templates. I'm like, okay, good luck. I mean, if you think you're going to reinvent it, everything you do every time, good luck, Chuck. All right, Johnny Romano, this is the end of our time here.
Well, this has been great. And I'm looking forward to seeing you. It will be very soon, Huntington Beach, and I am ready.
All right, because it is going to be the most extraordinary trial lawyers university ever. And we're only doing one this year, which is Huntington Beach. We're not doing Vegas because your friend Dan Ambrose is going to be the birth of the trial lawyer. So I'm on this journey for the next year. So I hope everybody's coming with me because I got to get some verdicts. So the only way we get verdicts, if I stop doing seminars and go to court and spend 12 hours, 14 hours a day on trials instead of putting together conferences. So that's what the next year is going to be about, Johnny R. So I'm coming to come see you in trial too. So
good. I love it.
I'm at Panish last week, Gallipo. It's really great. I love going to cases and being involved, even if it's just as a spectator and going back in the war room with Panish or Gallipo
it's awesome.
Seeing what they're doing to get ready for the next day. And Panish has got this whole team back there and everybody's working on stuff. And it's really cool because he's such a high level operator, such a great guy too. So it's going to be great, Mr. Romano. We're going to see you in about 30 days.
Dan, thank you.
Bye-bye.
This has been great. Okay, bye-bye.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.